Given the timing of defendant Brady's online dispute with Sixel, Brady's false copyright claims against Sixel, Brady's receipt of Sixel's true home address in the counter notification, and for the reported swatting incident, it appears Brady used the personal information gained through his abuse of the DMCA process to engage in swatting.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
Good morning, everyone. Hello, I am Leonard French, your favorite copyright attorney. I wanted to bring this to you as soon as I could, so I apologize in advance for the makeshift setup and the audio quality and video quality if they're not up to snuff, but I wanted to get this done as soon as possible. This is the lawsuit where YouTube is suing a person named Chris Brady, who is allegedly the person behind some of the DMCA ransom claims that we've seen. So I don't know if you remember, but earlier this year there were some DMCA claims that were pretty controversial because the person seemed to be making an abuse of the system that the system is totally set up for, completely set up for this kind of abuse. The system allows anyone to send a takedown. You don't have to verify ownership of a copyright. You don't have to somehow convince YouTube or the content host that the content is copyrighted and that you're the proper owner. You just send a takedown notice and the content host has to obey. So this person was sending takedown notices and then contacting the recipients of the takedown notices and telling them that they would be happy to remove said takedown notice if only they would pay a ransom fee of $150 or something like that. So let's see what they have to say here. This was just filed yesterday on August 19th. It was filed at about midnight, and so that's why some of the YouTubers were able to get videos out on the same day. This is YouTube versus Christopher L. Brady in the United States District Court for the District of Nebraska, and this is a complaint for violations of the Digital Millennium Copyright Act, 17 U.S.C. 512F, which is the misrepresentation section of the DMCA, which says that any knowing or willful misrepresentation in sending a takedown notice or otherwise acting within the Section 512 of the Act, any misrepresentation made in connection with that makes the sender liable for the consequences of said misrepresentation, the natural damages, the attorney's fees and costs, and things like that. So we do know from a Supreme Court case earlier this year that you likely don't get anything more than attorney's fees and court costs and transcript fees. You don't get investigation fees. You don't get your travel expenses. You don't get your expert witness fees. So let's look at this lawsuit. Defendant Christopher L. Brady has repeatedly attempted to harass and extort money from YouTube content creators through bogus allegations of copyright infringement. This lawsuit seeks to hold him accountable for that misconduct and for the damage he has caused to YouTube. In 1998, Congress enacted the Digital Millennium Copyright Act, 17 U.S.C. Section 512, otherwise known as the DMCA, to provide a framework for addressing claims of online copyright infringement. In general, the DMCA immunizes online service providers from claims of copyright infringement based on materials uploaded to the services by the users, if the services promptly remove allegedly infringing materials upon receipt of notices from copyright holders. Through these notices, the content of which is statutorily prescribed, copyright holders are able to secure the expeditious removal of allegedly infringing material from online services without the need to prove a claim of infringement in court. Users that receive infringement notices they contend are incorrect may file a counter notification by providing their name and address and telephone number and consent to service of process by the complaining party. Congress also recognized that these takedown notices could be used maliciously to secure the removal of content that was not legitimately claimed to be infringing. Accordingly, it provided a provision in the DMCA authorizing those aggrieved by fraudulent notices to bring an action against the senders for damages. This is such an action. They go into a description of YouTube as having approximately 2 billion monthly logged-in users. They describe YouTube as a free online platform that allows users to post videos and to watch videos posted by others. Users organize their videos, etc. Since its founding in 2005, YouTube has had a profound impact on commerce, culture, and politics in this country and around the world, etc. Defendant Christopher Brady is an individual residing in Omaha, Nebraska. Brady has sent YouTube dozens of DMCA takedown notices, falsely claiming that material posted by users to the service infringes his supposed copyrights. Brady has submitted these notices as part of a scheme to harass and extort money from the users that he falsely accuses of infringement. Brady has also threatened to send additional fraudulent notices to YouTube and to cause the wrongful termination of users' YouTube accounts unless users pay him off. And he has misused the personal information users have supplied when availing themselves of the DMCA's counter-notification procedure. So that's interesting. If it's true that he's using the DMCA to ransom people's YouTube accounts, that's extortion. That's criminal extortion. And those of you that were affected may want to contact the district attorney in Omaha, Nebraska, and ask them to file charges against this person for having done this. And then this person will receive not only the civil lawsuit from YouTube, but criminal charges from the district attorney if the district attorney decides to prosecute. Background. YouTube provides an online video service that hosts and makes accessible to the world hundreds of millions of videos. More than 500 hours of new video are uploaded to the service every minute. In accordance with the DMCA, YouTube has registered an agent with the U.S. Copyright Office to receive notices of alleged infringement from copyright holders. To trigger the takedown procedure, a copyright holder must send a notice of alleged infringement to YouTube's registered agent that includes substantially the following information. 1. A physical or electronic signature. 2. Identification of the copyrighted work claimed to have been infringed. Identification of the material that is claimed to be infringing. And information reasonably sufficient to permit the service provider to locate the material. That means you have to provide a unique link. You have to link directly to the material. Information reasonably sufficient to permit the service provider to contact the complaining party, such as address, telephone number, and email address. A statement that the complaining party has a good faith belief that the use of the material in the manner complained of is not authorized by the copyright owner, its agent, or the law. And 6, a statement that the information in the notification is accurate and under penalty of perjury, that the complaining party is authorized to act on behalf of the owner of an exclusive right that is allegedly infringed. YouTube facilitates the submission of takedown notices via a web form on its site into which a complaining party can easily submit the relevant information. To submit a takedown notice using the form, parties must affirmatively check a box next to a statement that reads, "I acknowledge that under Section 512F of the DMCA, any person who knowingly, materially misrepresents that material or activity is infringing may be subject to liability for damages." YouTube receives thousands of DMCA takedown requests each week through its online web form. It also receives notices by email, postal mail, and facsimile. YouTube invests millions of dollars each year to process these notices and to promptly remove allegedly infringing material from the platform. YouTube has also developed and maintains a robust policy regarding repeat infringers on its platform. If a user uploads a video for which YouTube receives a notice of alleged infringement, and the user does not counter the accusation by following the procedure set forth in the DMCA, that user is assessed a strike under YouTube's policy. In general, those who accumulate more than 2 strikes, 3 strikes, have their YouTube accounts terminated. Such terminations are made pursuant to YouTube's Terms of Service agreement with its users, which specifically calls out the potential for termination based on repeated instances or allegations of copyright infringement. Although users agree that termination of their account is a possibility, such terminations carry significant consequences for users. Users whose accounts are terminated are no longer able to upload videos to the service. Videos they have previously uploaded are removed from public view. Users in the YouTube Partner Program lose the ability to earn revenue from advertising shown in connection with their videos. Today, millions of channels from over 90 different countries earn revenue from their videos, including independent musicians and creators who are, in essence, small local businesses. In many cases, the revenue generated from their YouTube channel is their principal source of income. From 2017 to 2018, the number of channels earning more than $100,000 per year on YouTube is up 40%, and the number of channels earning more than $10,000 annually grew by 35%. For users who have spent months or years building substantial audiences and earning money through advertising revenues from their videos, the termination of their YouTube account based on accumulated copyright strikes can have a serious impact. Unscrupulous individuals are increasingly seeking to exploit the DMCA takedown process for illicit purposes. These individuals know that YouTube promptly removes allegedly infringing content in response to DMCA takedown notices, that it assesses strikes to the alleged infringers, and that it terminates the accounts of users who accumulate multiple strikes, often with severe consequences to the account holders. With that knowledge, these individuals can use bogus notices of alleged infringement as weapons. For example, an individual who objects to the contents of a given video may be able to cause YouTube to remove that video by submitting a notice of alleged infringement, without regard to whether the video actually infringes a copyright or whether the individual actually holds a copyright. While YouTube screens the notices it receives for such machinations, in many cases individuals go to great lengths to mask their identities and make bogus notices appear legitimate. Equally, if not more problematic, are situations in which an individual, motivated by avarice or animus, avarice is greed, sends knowingly false notices of alleged infringement in the hopes of causing YouTube to terminate a user's account for accumulated strikes. As noted, the consequences to such users from such contrived terminations can be severe. Again, YouTube works hard to prevent this sort of abuse, but sometimes does not succeed. Further abuse can arise because of the DMCA's counter-notification process. Under the DMCA, users who believe that their content was removed because of an improper takedown notice may ask YouTube to restore the content pending resolution of the question of infringement. To trigger the counter-notification process, a user must supply their name, address, and phone number to YouTube, provide details of the allegedly wrongful takedown notice, and consent to be sued by the original complainant. In accordance with the DMCA, YouTube forwards a copy of complete and valid counter notices to the original complainant. Instead of using the personal information in a counter notice for purposes of resolving an infringement dispute, abusive complainants may use it for purposes of harassment. YouTube users have uploaded an enormous number of videos to the service that relate to online video game playing. A significant number of these focus in some way on Minecraft, a popular online adventure game in which users can build or modify the game-playing environment. Minecraft videos run the gamut from those uploaded by the game developer itself to videos featuring users instructing others on the basics of the game, providing advice on overcoming specific in-game obstacles, or highlighting their own creations, experiences, and competitions. Users develop loyal followings on YouTube through their Minecraft videos. These users receive feedback from their audience using the comments, live chat, and other community tools offered by the service, and often their subscribers use these features to communicate suggestions, requests, praise, or anything else they'd like with the channel operators. Users that join the YouTube Partner Program can also earn revenue from advertising shown in connection with their videos. 3. Minecraft-related accounts on YouTube are operated by users with the account names Kenzo, Raids, and CXLVXN, for lack of a understanding of how to pronounce that. Kenzo has uploaded more than 300 videos and has an audience of 60,000 YouTube users. Raids has uploaded 100 videos and has over 10,000 subscribers. CXLVXN has uploaded approximately 500 videos and has approximately 20,000 subscribers. Additionally, as is common among gaming-themed channels, all three of these users frequently live stream videos without saving them on their channels. All three are also members of the YouTube Partner Program and are eligible to earn revenue from advertising shown in connection with their videos. Defendant Brady targeted the YouTube accounts of Kenzo and Raids, among others, in an extortion scheme. In January 2019, Brady used several falsified identities, sent YouTube multiple notices of alleged copyright infringement pursuant to the DMCA, claiming that 2 videos uploaded by Kenzo and 2 videos uploaded by Raids supposedly infringed copyrights that he owned. Defendant Brady's notices of alleged infringement included the various representations required under the DMCA. Brady identified the specific locations of the videos posted by Kenzo and Raids. He represented that he was the original creator of those videos, that he held the copyright to them, that the videos posted by Kenzo and infringed his copyrights, and that each of his notices was accurate. He certified, in capital, under penalty of perjury, I am authorized to act on behalf of the owner of an exclusive right that is allegedly infringed. Brady even included links to other copies of the videos in question as proof that he created them. Defendant Brady's notices of alleged infringement were fraudulent. The videos posted by Kenzo and Raids that Brady identified in his notices did not infringe any copyright supposedly owned by Brady. Brady knew that at the time he sent the notices. Brady also knew that he did not hold the copyright to the videos he identified as his own in the notices. His certifications under penalty of perjury in the notices were knowingly false. Defendant Brady sent the notices of alleged infringement for the improper purpose of inducing YouTube to remove the identified videos and assess unwarranted copyright strikes on the Kenzo and Raid accounts. Upon receipt of Defendant Brady's notices of alleged infringement and unaware of their fraudulent nature, YouTube removed the videos that Brady identified as allegedly infringing in the notices. YouTube also assessed copyright strikes on the Kenzo and Raids accounts. On January 29, 2019, shortly after sending YouTube the notices of alleged infringement, Defendant Brady, masking his identity, sent a message to Raids that read, "Hi Abby, we striked you. Our request is $150 PayPal or $75 Bitcoin. You may send the money via goods services if you do not think we will cancel or hold up our end of the deal. Once we receive our payment, we will cancel both strikes on your channel. If you decide not to pay us, we will file a third strike. We'll give you a very short amount of time to make your decision." Having submitted knowingly false notices of alleged infringement regarding Raids videos, Defendant Brady, that's funny, they used the apostrophe on the Z of Raids to make it possessive. I don't know if that's right. I think you're actually supposed to use the apostrophe S after that. Raids sounds weird, and I wouldn't even say it that way. But like, the possessive apostrophe doesn't go after a Z. Defendant Brady offered to rescind those notices so as to prompt YouTube to reinstate the videos and remove the strikes if Raids made an unwarranted payment to him. Similarly, Defendant Brady, masking his identity, contacted Kenzo and demanded $300 via PayPal or $200 in Bitcoin to rescind the notices of alleged infringement he had sent regarding Kenzo's videos. Brady threatened in that message that if Kenzo did not comply, Brady would send additional notices of copyright infringement, resulting in assessment of additional strikes and the termination of Kenzo's account. Defendant Brady participates in the Minecraft gaming community and appears to have interacted within the game with various YouTube users, including Kenzo. Brady's extortionate and harassing activities described here may at least be in part motivated by his failings in his Minecraft interactions. Let's read that again a little more enthusiastically. Brady's extortionate and harassing activities described here may, at least in part, be motivated by his failings in his Minecraft interactions. YouTube did not learn of Brady's fraud and attempted extortion until the users, Kenzo and Raids, publicized their experiences. YouTube immediately investigated the matter, restored the videos in question, and removed the strikes that had been assessed to their accounts. So there you go, guys. You've got court confirmation that YouTube watches Twitter and other social media, and I'm sure its own contact forms and everything. And if you are complaining about this kind of extortion or a false strike or something like that, they might actually investigate it. So although we don't really like that only people who go public get customer service, That seems to be the norm these days. If you want a company to give you customer service, you have to do it publicly. You have to go online and shame the company into helping you. If Abi Raids and Kenzo had not publicized their experiences, YouTube would not have immediately investigated the matter, restored the video in question, and removed the strikes. That's what they just said. Between June 29th and July 3rd, 2019, defendant Brady submitted 4 more DMCA takedown notices to YouTube, this time targeting the CXLVXN CXLVXN channel. Again, these notices were fraudulent. The videos posted by CXL did not infringe any copyright supposedly owned by Brady. Brady knew that at the time he sent the notices. Brady also knew that he did not hold the copyright to the videos he identified as his own in the takedown notices. His certifications under penalty of perjury in the notices were knowingly false. So it seems like YouTube may not have been ready to sue until Brady made this additional DMCA extortion claim. A review of Brady's and CXLVXN's Twitter accounts at the time of the period suggests that they were engaged in some sort of online dispute, and it appears that Brady sent the notices of alleged infringement for the improper purpose of inducing CXLVXN to submit a counter notification, thereby exposing his home address. CXL submitted a counter notification on July 4th. On July 10th, he announced via Twitter that he had been the victim of a swatting scheme that day. Swatting is the act of making a bogus call to emergency services in an attempt to bring about the dispatch of a large number of armed police officers. So, CXL might want to contact the district attorney of Omaha, Nebraska, and complain about Christopher Brady's swatting of CXL. Given the timing of defendant Brady's online dispute with CXL, Brady's false copyright claims against CXL, Brady's receipt of CXL's true home address in the counter notification, and for the reported swatting incident, it appears Brady used the personal information gained through his abuse of the DMCA process to engage in swatting. Defendant Brady's false complaints were all submitted using YouTube's complaint web form. Thus, Brady, with each complaint, checked the box that reads, "I acknowledge under 512F of the DMCA, any person who knowingly misrepresents that material or activity is infringing may be subject to liability for damages." So here's their cause of action. The first cause of action, 17 U.S.C. 512F. On at least 24 occasions, Brady sent YouTube notices of alleged copyright infringement pursuant to the DMCA that contained knowing and material misrepresentations that videos posted by third parties to the YouTube service infringed his supposed copyrights. YouTube, the service provider that received defendants' bogus notifications of alleged infringement, relied on defendants' misrepresentations, removing or disabling access to the material defendant falsely claimed to be infringing. Defendant Brady has gone to great lengths to hide his unlawful conduct, using at least 15 different online identities, all of which YouTube has traced back to him. Brady's abusive behavior has caused YouTube to expend substantial sums of money on its investigation in an effort to detect and halt his behavior and to ensure that users do not suffer adverse consequences from it. Defendant Brady has demonstrated that his abusive behavior will continue if left unchecked. So that does seem to me like maybe YouTube wasn't going to do anything until this previous incident with CXLVXN. And I'm sorry, I'm probably pronouncing CXLVXN completely wrong, but that's the best I can do. In part because of Brady's constant attempts to mask his identity, YouTube may be unable to detect and prevent similar misconduct in the future. Injunctive relief is necessary to prevent irreparable harm to YouTube and its users. Irreparable harm is the standard for injunctive relief. That's what they're saying there. So they're also asking for injunctive relief. So YouTube is asking for compensatory damages, costs and attorney's fees, a preliminary and permanent injunction barring defendant Brady and all those in active concert with him from submitting notices of alleged infringement to YouTube that misrepresent that material on YouTube's service is infringing copyrights held or claimed to be held by Brady, and for any other further or different relief as the court deems proper under the circumstances, and that is August 19th. So that is really remarkable. So it turns out that not only was Brady sending false copyright notices, he was doing so to extort money from people so that he could feel like he'd won an internet argument. That is the most fragile ego I've seen this hour. I'm sure you will see another one as soon as certain leaders of the free world tweet. As far as the truth or falsity or the veracity of YouTube's claim, the only way this could really fail is if somehow it turns out that Chris Brady's the wrong defendant. If all of this is really tied to Chris Brady, then it seems an open and shut case. Maybe they have a few things to prove, maybe they have to make some connections and things, but this is the civil standard. We're on what's called preponderance of the evidence. Whoever is more convincing wins. So we're going to see who, with regards to YouTube's case that we just read, or Brady's defense, which one do you think is going to be more convincing to the judge? Now, we haven't heard Brady's response, and it's not fair to act like he's been found liable or convicted of a crime before any of that happens. So nobody do anything about Chris Brady or harass Chris Brady or anything like that. We can call him names. We can call him the scumbag, the extortion person that he is. We can call him a future convict, maybe. But right now, this is just an accusation. But it's a pretty strong and pretty damning accusation. Many of us did see Abi Raid's public tweets and public furor about the extortion notices that he received. So it's not like we don't know that this happened. And it's not like we don't know that this was wrong to do, that it's wrong to send a DMCA takedown notice. We always talk about false claims and fair use and all that. This is what has to be done. I personally feel that YouTube must pursue abusers of the system like this. And even more, I really think that the District Attorney of Omaha, Nebraska should pursue criminal charges against Chris Brady if they haven't already. In fact, why don't I take a moment and look up whether we know of any criminal charges against Chris Brady. Criminal court search here. Let's see. $15 per search. Hey, could you bring me my jacket? It's got my wallet in it. No results found. So he doesn't have a previous criminal record. Yeah. All right, so there you have it. Chris Brady doesn't have a criminal record yet. This would be a good time to start on that. Someone who is willing to extort money from other people deserves to go, at least be charged for it, possibly go to prison if it's that egregious. Maybe this isn't that egregious, but the person definitely deserves to be charged. So lawsuit is great. I'm really happy to see that, and I think we should all contact the Omaha, Nebraska District Attorney's Office, maybe forward a copy of this complaint and explain that extortion is a criminal offense and that we hope that the District Attorney will charge Brady with extortion as well. Oh, and then swatting. Let's not forget the swatting. I mean, that got somebody killed in Kansas City last year. So no, we can't allow swatting either, so it should be charges of extortion and swatting. So what do you think of that? Let me know in the comments below. Let me know what you think should happen to Christopher Brady and how you feel about using copyright law to extort money out of someone by threatening their livelihood on their YouTube channel. That's pretty scumbag. Like, translate that to the real world. Someone went to your job and told them you're stealing copyrighted works, so in the hopes that you would get fired, and then only after they revealed a ransom demand, an extortion scheme, were Abi Raids and the others able to show their employer. I understand YouTube's not the employer, but this is how it translates to the real world. They show their employer, look, I'm being extorted, and then the employer's like, oh, I'm sorry, I fired you. You can come back to work now. Great, I'm glad that got resolved, but that's what happened. Like, someone got somebody fired from YouTube, basically, for a copyright offense. So this is all something that's allowed by law and has to be wrapped up or remedied after all the damage, rather than making sure that someone owns a copyright before you incur all this damage. We put it on the people who create the copyrights in the first place, like me, to have to receive this damage and then do something about it afterwards. I think it should be on people like Brady to have to prove it first, so that the damage is on Brady, and Brady can sue me for the damage if I'm damaging Brady. Look how easy it was for Brady to damage the others instead, because of the way the system is set up now. Right now, all of the burden is on the copyright creators to not let themselves get extorted and to file a lawsuit after a false claim, etc., etc., etc. There is no other remedy than going to court, and that bothers me. It's great that YouTube investigated this one instance and did something about it. There are hundreds of other instances that YouTube has not been able to do anything about, and there's lots of hidden instances where just because people don't want to go public with their dispute, they don't get remedies, they don't get relief, they just get to suffer. That's not right. So let me know what you think of the situation, and we'll see you in the rest of the videos that drop. Love you all. I'm Leonard French with Lawful Masses. Let me do my quick outro here. Thank you very much to our supporters in August of 2019. Thank you very much to Joshua Davis from TandaPay at the $500 level. Really appreciate your support, Joshua, and we're working on your TandaPay video, which we'll hopefully release very shortly here. Thank you to the $50 plus supporters, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Jan Negrey, Blackleaf, Spirit Bear, Daniel Perez, Snorre Wisotzky, NotMike, Joe Tyson, and King Macro. Thank you guys very much for your support, as well as the $5 plus supporters. All of these supporters will be in the description of the videos below. Thank you very much for your support. Thank you very much for watching. I'm Leonard French, your favorite copyright attorney. This has been a special video from Lawful Masses. I'll see you guys later. Bye.
Pictured it, and I wanna do more than talk. Nothing like